are we applying? Never before in the history of this court have these tests ever been applied. That's why there are no judgments cited, Bharat. So, Maharaj, the mistake in Basha was that when Basha said that you have not established this university as a minority, then the council argued, but I am administering it. And Basha said, you're not. That's not the test. So Governor General does this, Rector does this. Malaj, I want to ask myself a question. If I am enacted by an act of the Central Legislative Council, Malaj, will there not be a structure by which somebody has to see that I'm not maladministering? Take our constitution today, I set up a minority institution, Malaj. When I'm setting up that institution, will the chancellor of the institution, which has nothing to do with the minority, not have the right to inspect? He'll have the right to inspect. He'll have emergency provisions. He may even have the right to take over. Administration doesn't mean maladministration. So let's start with the proposition that I have a right to administer. Your Lordship asked a very fundamental question, but the 81 Act is not a status quo ante. Your Lordship is right, but I accept it. I accept it. I'm not a minority institution. I still am. That's my choice. And that's the other mistake that we are making, which is an error of law. I don't have to be administered either by the Muslims or the Christians when it comes to minority institutions. You won't have Christians or you won't have Muslims, Mullahs, who are educated at that level to be in every. So, Mullahs, TMA Pi had 4 tests. Para 50 of TMA Pi set up 4 tests. What do you mean by administer? Mullahs, just kindly come. I've done a rejoinder, Mullahs. It's also part of the. Kindly come to note 1G. Yes. Page 3 of note 1G. That's why, Mullahs, my learned friends, when I argued this in the beginning, never answered that question. Because 1906 regulates minority institutions as much as it does majority institutions. Regulation does not mean destruction of the right. So if the chancellor is appointed, Mullahs, by the president, it doesn't mean that I've lost my right as a minority institution. So Mullahs, kindly see the TMA Pi para 50.
Where do we get it?
Mullahs, that's my volume 1G, Mullahs.
At page?
Page 3.
Yes.
Ambit of right to administer was set out as including the right to admit students, subject to an objective and rational procedure of selection. No problem. That's the institution as the right. The minority, once I establish the institution as a minority institution, I have a right to admit students in accordance with procedure which is fair and transparent. Perfectly good. I'm doing that in Jamia, in AMU. 2, set up a reasonable fee structure. The institution is doing it. 3, to constitute a governing body. We have a governing body. It doesn't say governing body, we must have all Muslims, or governing body, we must have all Christians. Where is it said? Where is that test? 4, to appoint staff. Appoint staff. Now, Mullahs, the university says if you want to teach in AICTE, the teacher must have these qualifications. Abide by that. But the right to choose the teacher is mine. In Delhi University, Manoj, the university provides that if you want to teach economics, the person must be a doctorate or whatever. The choice of which doctorate will teach is mine. But the university will set the standard. That's what it is, to appoint staff teaching and non-teaching. Standards set by the institute, by the structure of the university. And 4, to take action if there is dereliction of duty. These are the 5 indicia of administration. That's 11 judges. Now test this in the context of what Basha said. Now kindly come to Basha for a minute. 3A. Yes.
Is to establish and
Yeah, I know. In page 16. Yes. I'm sorry, page 16 of Basha at volume 3A, page 16. Animals pracetum GNH. Wrong argument, therefore the wrong answer. It's not a twin test. Am I administering? That's not the test. And we have all, throughout these days, we've been arguing about, show me if you're administering. It's not required by 30. You'll never get that, Mullahs. That means there will be no minority institutions left in this country. Apply this even to the institutions after 2005. All the provisions that are here in the 81 Act are all there in 2005. Inspection, emergency, a final approval, all that. I've got a chart, I'll show it to you. So what are we trying to do? Apply a test which will destroy the entire minority structure, Mullahs, of education in this country?
They don't read.
That's why, Mullahs, if your lordships remember, in the opening I said, and your lordships put it also, that your argument is that if I cede that right, that's my choice. To the extent that I cede it. If I feel somebody is interfering, I can challenge it. I can challenge it. I have a right to administer, not a duty that I must administer everything. And no judgment of any court since 1950 has held this. That's why I got up and said that numerical strength is not an issue, can never be. I am satisfied with this, Malaj, and I will go numerically also. Out of the external members, Malaj, I am 77 out of 104. But, I don't want to fall into that trap. That's why I choose not to challenge. I'm happy. So this is the fundamental constitutional issue that your lordships will have to decide, and consistent with judgments of this court. It's not a twin test. I have the right to establish, I have the right to administer, and of my choice. So, Malaj, if I am within Delhi University, I am an affiliated college, I accept the discipline of the university. So what is the only choice I have in St. Stephen's? Some element of reservation. That's all, nothing more. And I appoint my own teachers, I dismiss my own staff, I take disciplinary action against him. I have an admissions policy, which now, Malaj, I don't want to talk about it. That's pending in this court. I had an admissions policy where I could admit students, but with standards. Your lordship knows in private institutions also, those standards had to be applied. You can admit. The Christian Medical College, your lordship knows, they used to hold their own tests at one time. And they had their own standards. The court said, no, when you come to medical seats, you should go by NEET. Fine. That doesn't mean it's not a minority institution.
Mr. Subbal, one clarification.
Yeah.
Just please see one head note above paragraph 48 in TMFI and just clarify, para 50 applies to
Minority or
minority government aided.
Yes, I'm on government aided.
Just clarify that part.
Yes, I'm government aided.
You are government aided, but see the head note above para 48.
private, unaided, non-minority educational institutions. That is the heading.
That applies also to government aided. That also applies to government. It makes no difference.
What page is it?
It's all right, non-minority. Same principle applies. Same principle. We are talking about administration. Well, please appreciate. We're talking about administration, nothing to do with minority, non-minority.
50.
I said the test of administration.
So whether the same test would apply
It
for a
will have
minority.
to, it will have to, under 30, it will have to, Malaj. Your lordships have never said otherwise.
Somewhere provided as to what would be the test for minority. Because this is specifically dealing
Malaj.
with private, unaided, non-minority.
Because the argument was that we should not be subject to anything. I am on, please appreciate. Let's test it on first principles. The meaning of administration can't change, Malaj. Let's test it on first principles, Malaj. Let's test it on first principles. What does administration mean? Whether it's minority or non-minority makes no difference. Administration can't vary if an institution is aided or unaided, or minority or non-minority. The meaning of administration can't change unless you find it in section 30 that not only do I have the right, but I must administer the institution all by myself.
Mr. Subbal, your argument being.
Well, para 5 only explains what the right comprises, or 50 only explains what.
It says to admit students.
Yeah.
Therefore, a private institution may say that I will admit only a particular category of students, students belonging to a particular category. It's a private institution.
Can't say. Can't say. If it wants a degree, it cannot. Well, I'm sorry.
No. This is only institution. TMFI was not concerned with university.
No, it was considered, we're dealing with everything, schools, universities, institutions, everything. But let's pause here. I am a non-minority, unaided institution, but I want a degree. I'll have to abide by the admissions policy. But I can, within that, admit students of my choice on merit. See, let's talk of first principles here. The right to administer cannot
Can you
change.
say that in a particular course,
Yes,
100% would be from a particular category?
cannot be.
Can you say, you can't do that?
You can't.
Can you say that 50% would be from a particular category?
In minorities, yes. That's the law. Yes, that's the law. Within minority institutions, yes. And merit. We can't do away with merit. But that doesn't mean that I've lost my character or I have surrendered. Therefore, let's be clear on first principles here.
No, because in 2004, for the first time, you sought to reserve 50% for the PG course. Prior to that, you did not.
I tell your lordships why, because I'll come to that later. The area of maneuverability, as I was concerned, had been reduced from 50 to 25%. So therefore I wanted. And it was struck down, according to me, maybe rightly, but that we're not on that. At the moment, Millers, we are discussing the fundamentals of Article 30. Where do you get this proposition that a minority institution for the Muslim community must be administered only by the Muslim community? Not in Article 30, not in any judgment of this court, not even in TMFI. And this is the proposition that Barsha Mullahs proceeds on. Look at the rector, look at the Governor General, he is not a Muslim. Well, that's the argument. Does the President of India have to be a Muslim to get St. Stephen's minority status? What kind of argument is that? Yes. Which page? Well, if this were the test, there'll be no institution, Mullahs, which can never claim to be a minority institution in this country.
Argument is, as if a minority establishes an institution, that's good enough for compliance, for getting protection.
Yes, under 30.
Under 30.
Correct.
It's my right, thereupon it's my right to administer. And my right to administer includes these 4 points.
Correct. You may expand it, Mullah, I have no problems with that. But the right to administer is my choice. I can give up certain rights. I can't waive a fundamental right, as your lordship knows. But I can give it up for the time being. If I find still interference, I can challenge it. I can choose not to challenge. So St. Stephen says, I just read that. It says the right, exactly what my lord has said. The right claimed by a minority community to administer the educational institution depends upon the proof of establishment of the institution. The proof of establishment of the institution is thus a condition precedent for claiming the right to administer the institution. That's exactly what my lord said. And Basha also says that. But Basha says, but you are not governed by Muslims. In fact, Basha should never have gone into this question. If Basha came to the conclusion that that this is not established by a Muslim minority, there was nothing to, it should have stopped there. Why it didn't stop? Because we made the argument, even if we are not established, we are administering the institution. It's a mistake on our part. It's for the first time, my learned friend is agreeing with me on this. And university was not a party. No,
My learned friend is in rejoinder. There are several statements which are either inaccurate or misleading.
well, as I'm
But
sure
we won't
my
have
learned
the
friend is,
chance to.
my learned friend is very kind always to say that everything that I say is misleading the court.
Not
And
everything.
the politeness of my learned friend with which you say it is admired by me.
Not everything. I didn't.
Well, what is it that is misleading? Make one statement that is misleading. One statement. Don't just get up only for the sake of getting up.
Mr. Sibal, what is the meaning of para 54 of St. Stephen?
54. Volume 5, yes. 5A, yes. Paragraph 54. Which page is that? Page 422.
St. Stephen's is page 4.
22, my
Page
lord.
50, para 54. It's
420.
5A, page 422.
Yes. That's exactly the point.
Particularly the line,
Yes.
this management must be free from control.
Correct. Or the founder or their nominees can mold the institution as they think fit and in accordance with their ideas of how the interests of the community in general and the institution in particular must best be served. Entirely in agreement with what I'm saying? Entirely, Malad. That's my choice. Supposing, Malad, the Vice Chancellor of Delhi University said, I will appoint your teachers. I will decide who will teach in the university. It will be violative of 30. And see, read the rest of the paragraphs. It's all in my favor, Malad. But the standards of
The
education,
funds, as you like,
I'm sorry?
whatever public funds you receive,
Yeah.
can you use it as you like?
No, Malaj, I'm grant in aid, 90% Malaj, grant in aid is given to me. That's, and TMA Pi says, the fact that you're rated has nothing to do with the minority character of the institution. You still retain the minority character. Aid is fundamental.
So the
Duty.
fact that your accounts are audited by the CJI,
It's audited.
does it not make any difference?
No, because it must be audited. I am not absolved of the general principles of law applicable, Malaj. That's nothing to do with administration. Malaj, to prevent mismanagement, to prevent maladministration. That's why, Malaj, it is to be audited.
Page 416.
One second, hold on, sir, if you don't mind. Allow me, I don't interfere like this, please. Allow me.
Part was not right, but I leave it.
I'm sure.
Very good.
Please leave it at that.
Please leave it.
Yes.
There are 36. They do have the number test.
Again, do have the number test means what?
416.
You'll find out what it means.
Reading the paragraph. This only, okay, establishment of the institution, nothing to do with the administration. Again, you are misleading.
The management.
One second. This is how the institution is established. Bishop of the diocese, who shall be the chairman? The persons appointed by the bishop of the diocese.
Says management.
He's not managing the institution. This is the genesis of the institution.
Management.
The North, but let's not have I'm before the court, not before you. The day you become a judge, I'll argue before you.
Come on now, let's.
Anyway, Malad, let's not deviate from the issue, Malad.
That means 36 does help me.
One second. Sir,
Justifies that 36 does talk of management, does talk of
if
administration.
you don't, I don't understand what my learned friend is unnecessarily, Malad, I don't know why.
Anyway,
Keep on.
All right, yes,
One-
Mr. Sibel. Yes, we now go virtually the end of the arguments. Yes.
No, it's not the end, Malaz. It happens to be just the beginning of my argument.
You've got 1 hour and 15
Malaz, I
minutes. here.
can't possibly finish,
So
Malaz.
we'll close today. We are not. We have another matter listed next week.
Malaz,
Today, one.
it's impossible to.
We don't mind continuing beyond 4 o'clock, but Mrs.
But
Sibel, we have to
I
get-
have not, I have not raised any new point. I'm just trying to answer.
No, but this point which you have made, that it's your right to establish, it's your right to administer, and merely because you choose any third party to administer doesn't take away your right to administer in a manner which you think is appropriate. That's the point.
That's
You
the
got-
point. That's the point,
It's a
Malaz.
right and not a condition.
Yeah,
Qualification.
that's correct. That's all, Malaz. It's not a right, not a condition, Malaz. Absolutely right. Not a directive, not a condition, not a directive, St. Stephen says so. So, Malaz, having said that, Malaz, now see what mistake Basha made. Okay. 16. Volume 3A, page 16, Malaz. Okay. Page 16, placitum G and H, Malaz. An argument has been raised, Malaz. Might just have that. What's the time? Okay.
1-7.
Placitum G, Malaz, at page 16, volume 3A. Plus TMA pi answers the question of 8. TMA pi answers the question of affiliation. None of these conditions, Malaz, can take away from the character of the minority institution. So that, Malaz, is already covered by 11, this judgment of 11 judges. But Malaz, kindly see, if your lordships don't mind, Malaz, placitum G, paragraph 3A, at page 16 of Malaz, volume 3A, Basha, Malaz, volume 3A, page 16, between placitum G and H.
Age Basha is right.
It's consistent with St. Stephen. That's what I'm saying, Malaz. I'm saying exactly that. But then what does Basha say? Kindly see the other paragraph. Page 17. Between E and F, Malaz, you see the two words in Article 30 must be read together. And so read, the article gives the right to a minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer under 30. Perfectly good. Then, Malaz, what does the argument? We have therefore to consider, to examine closely what happened in 1920 when the Act was passed to decide whether in the face of the Act it could be said that Aligarh was established by the minority, whether the right to administer it ever vested in the minority. That's the wrong thing. This is ultimately the conclusion. I'm sorry. There was the other passage which says, no, that it at page 22, in paragraph F, nor do we think that the provisions of the Act can bear out the contention that it was a Muslim minority which was administering the Aligarh University. Well, this is wholly irrelevant. That's not the test. The issue is not whether the Muslim minority were administering the university. Already, Malas, the Basha said, if you've established it, you have a right to administer.
But then why did you challenge the 1951 and 1965 amendments?
I'm sorry?
Why were you mean the sense? Why was the 1951 and 1965 amendments challenged in the first place?
Because it took away my right to administer.
Right. Therefore, that's exactly the point. So the 1951 and 1965 amendments were challenged.
I
on the
did
ground.
not challenge, but
Somebody
challenged.
Right. AMU didn't challenge.
Yes.
It was challenged on the ground that both these amendments took away the right to administer.
Yes.
How did it take away the right to administer? By creating institutions for the governance of the university in which people who are not of the faith or of the confidence of the founders would be brought in. That was the essence of the challenge. Otherwise, if your argument today is right, that once you have established, you are entitled to decide how to administer, then there was no reason to challenge the 51 and the 65
With
amendments.
respect, there is a reason, Malas. The reason was they took over the entire control of the university. I was under Basha, not a minority institution.
Therefore,
I was not a minority institution under
therefore,
Basha.
how did they take away the control of the university? They took away the control by, for instance, regulating. First, it said that the proviso to 23 was deleted. Secondly, the constitution of the court was altered.
Correct.
Then they brought in the concept of a visitor.
Correct.
They brought in a whole lot of other changes.
Correct.
Now, that was alleged to be, that was challenged on the ground that it takes away the right to administer.
Correct.
Now, if that be so, if 81 is not under challenge.
No.
Now, if 81 does not restore the position as it stood entirely prior to 1951,
Yes.
then the amendment which is not in challenge has not, though it purported to do that, it has not in fact restored the position prior to 1951.
I agree, Malas. I'm happy with 81. I have no problem with 81.
That's exactly, but you can't be happy with 81.
Why?
Because 81 doesn't go far enough.
No, it's far enough for me, Malas. Please appreciate what I'm saying. It is far enough for me. I am 74 out of 104 in the external members. The court is restored. My voice is heard. The Old Boys Association are represented.
But
I'm happy with that.
That is not because of the 81 amendment. It is about how the working has actually panned out.
No, it's in the 81 amendment, Malas. I'm sorry.
81, if you look at the 81 amendment, the constitution of the court, it doesn't give you 74 out of 100.
It does. I'll show it to you. It does, Malas. Point is, this is the mistake I am making, Malas. I'm sorry. This is not the issue at all. As I said to you, on that ground, St. Stephen's is not a minority institution.
But if you are right,
Yes.
that once you establish,
Yes.
then irrespective of whether you administer or not, it's your choice. You can leave administration to a third
I didn't
party.
say that. Irrespective, once I establish it, if the government interferes in my right to administer, I can challenge it. That's all. Nothing more than that. If there are regulations which seek to destroy that right, I can challenge it. But that's the limited argument I'm making. I can even challenge some of the 81, but I'm happy with it. Because it continues, my character is maintained. I have no problems with it. What my Lord is putting to me is that I must demonstrate that I am administering as a Muslim the university. No. I was at that point in time in 1920. I don't have to go back to that position. Where does regulation end and infringement begin, Malas? That's the question. That's my right. I have to decide that. That, Malas, with respect, even the court may not decide. Where does regulation end and where does the infringement begin is something I have to decide, Malas.
Well, the difficulty is when we started the arguments, you said we are not going to the question of or, we accepting or should be read as and. Now your argument today is slightly different. What you're saying is, once the minority decides to establish, within inverted commas, establish an institution, then two rights flow. One is they have the right to establish, which is the first right, which is connected with the rights of the minority to establish. And there's a second right, right to administer. Right to administer cannot be read as a condition precedent for declaration as a minority.
That's right. That's what
It's the
I've always maintained.
consequence, not the condition.
Yes, I've always maintained that, Mullah.
Now you raise the argument in a very different way.
No, Mullah, but I have always been saying this. And the other day I said to my Lord, the Chief Justice said, that means if you give up your right, you're happy with it. I said that, Mullah, I remember that.
Because now you are arguing it and should not be read as or.
It cannot be read as or, Mullah. And it's a right, Mullah. There's no question of or. Mullah, it is and.
You have both the rights.
Yes, I have both rights. I've always said that. I've never said or, Mullah. I've never contended or. It's a right to establish and a right to administer. Now, my right, when somebody infringes my right, whether it's the university or the government, I can challenge it. But to the extent I'm administering it, I feel that if this element of free play in the joints is good enough for me, I'm happy with it. So I'm not in any way saying, Mullah, see, 65 was challenged by somebody, Mullah, but the de facto continued. So in a sense, right from 1950 onwards, this has been an institution, Mullah, which has been actually serving the interests of the minority community, de jure and de facto. I say, Kerala Education Bill says it must not be overlooked that 31 gives the minorities two rights, to establish and to administer educational institutions of their choice. The second right clearly covers pre-constitution schools. This is exactly what, this has been the law throughout, Mullah. I've never said anything different, but I happen to have argued most of these matters. Otherwise, you'll be laying down a test, Mullah, as I said, no minority institution can ever claim to be a minority on this basis. Article 32 only contains one, Mullah. It doesn't contain two tests. I'll have to show that I established the institution. And the Church of North India established, Mullah, St. Stephen's College. That's the fundamental, Mullah, issue. Basha answered it wrongly because Basha said, no, the Muslims were not administering. Where is it in Article 30 that only the Muslims must administer, or the Christians must administer, or any other community must administer? And what is administration? Running, well, that's the other thing. What is administration? Running the day-to-day affairs of the institution. That's administration, I hope, Mullah. Nothing more than that. If some statute has to be approved by somebody, that's not administration. I have to run the university in accordance with the law. Law is 1906. And well, nobody's answered 1906 on the other side. I've been saying again and again, apply that 1906 to pre-1950. These were all regulations. Of course, somebody had to approve. It was the British Empire under which we were being governed. There was a Governor General. There was a proctor. Somebody had to be there. But that's not administering. Administering is running the day-to-day affairs of the university, which means appointing your teachers, holding examinations, admissions of students. That's what administration is. Administration is not some approval that is to be taken by a statute. How many times, Mullah, do you think St. Stephen's have any role to play in an approval taken by a statute, Mullah, or the Executive Council or the Academic Council or the ordinances of Delhi University? Nobody takes. We are governed by it. We're governed by, that's 1906. So these are all regulations of 1906.
Mr. Sibal, with your argument, then standard of administration of one minority institution will be different than the other minority institution.
Always is.
Because St. Stephen, see the level of what was the interference by the university. and how this court turned down that interference. So now you are accepting that there can be an appointment of a vice chancellor, appointment of a visitor.
Always has been. All minority institutions. Never an exception.
But in that case, the standard of administration in your case will be different than those.
Always another minority institution. Yes. Or other institution. Of course, because the teachers are appointed by me. That's admitted, Mullah. That's the accepted position. That's the administration, Mullah. Everyday running of the university. How do I run the university? How do I run the hostel? The appointment of teachers, disciplinary action against employees. The university doesn't take disciplinary action against my employees. It will take koi others, Mullah. He can go to court and say, look, this is wrong. That's fine. So, Mullah, all that is governed because that's regulatory. That's 1906. Just read 1906, Mullah. Just read 1906 with me. Nothing in clause G of the said clause shall affect the operation. Sorry, this is 5. Because it's a, it's an occupation. Yeah. Nothing in G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right. That's all. Now, if I find any particular restriction to be unreasonable, I will challenge it. So all these are reasonable restrictions. If approval of the proctor is to be taken, is a reasonable restriction. If inspection is to be done, Mullahs, if there are any misgivings about the way it is functioning, that's a restriction. It's reasonable. And that's exactly, therefore, your lordships have said time and again, right to administration is not the right to maladminister. The moment there is maladministration, you lose your right under Article 30. And it's nobody's case that AMU is maladministered. I've been hearing from the other side, it's a great university. It's a university of great excellence. So obviously, I must be administering it okay. And it is. So with the greatest respect, Mullahs, please do not apply a test which may be constitutionally suspect. Please do not do that. And therefore, Mullahs, we are going wrong because Basha went on a wrong footing to say that, look, it's not administered by Muslims, therefore, Basha need not have answered that at all because Basha ultimately says, because you're not established, you have no right to administer anyway. But then 1968 judgment took off on that basis. So, Mullahs, I've done with this. I've made my submissions. Then the second submission is that, I'm sorry, Mullahs, yeah, 1 second. I want to show your lordships, Mullahs, factually. Kindly come to my submissions, page, volume 1G, page 15. Yes, 1 second. No, 14, 15. Kindly see. So, Malas, we have all that that's why, Malas, I've been saying throughout, all you have to decide is whether Basha is rightly decided or wrongly decided on an establishment. The rest will follow. Then I have a right to administer whatever the act is. If I feel that some provision is violative of my right and it's infringing my right, I'll challenge it. If not, I'll be happy. That's all that your lordships have to decide. Then, Malas, the other thing I want to say, Malas, my learned friends kept on saying there's a decision of a fact. How can a legislation overturn that fact? What's the fact in Basha? The only fact in Basha that is decided is that because you incorporated, you're not established by the minority. Or is there any other fact that was established? That's the only fact. That's all. That's the fact. The rest of it is interpretation of legal provisions. How is anybody overturning that fact? In fact, the 1981 Act, in fact, takes away the basis. And I tell your lordships why. Now kindly come to 1G. So there is no other fact decided by Basha. He says, because the statute says you were incorporated and established, therefore you are not a minority institution. That is the only fact. Ignores everything else.
How did it take away volume 1G?
Yes, kindly now see, Malas. It's very interesting. I'll just give your lordships briefly, orally, the background. The background is that when from the beginning attempts were being made to set up, we set up the college, AMU college, and then ultimately, actually, originally we wanted to set up a university. But when the college was set up and talks were taking place of how this is to be done, we ourselves said that we want to establish a university. And we'll allow supervision by the government, but we want to be independent. No interference by the government, otherwise we'll not go forward. I must kindly have a look at page 15 of my note. Letter dated 14th June 1872 from Sir Syed to Eliot. I've given Malas the volumes, so therefore there's no need.
Page
Bringing
15?
to his attention,
Page 15, right?
page 15. Paragraph 18, small a. Does it have it or no?
Paragraph?
Paragraph 18A, page 15 minutes, PDF 15.
18 ऐसा नहीं है.
The problem?
18 and then 19, there is no 18.
Yeah, there's 18 and then 19 actually.
There is no 18A.
18 is
18A.
hence AMU was able to demonstrate.
Yeah, small a, minutes, small a.
No,
There's none.
18 starts with, hence AMU is able to
No,
demonstrate.
I'm talking about my rejoinder submissions, which is volume 1G.
1G, yeah, we earn 1G.
Huh? Oh God, you've not uploaded the right version. Been uploaded.
आपके पास ये hard copy है?
Unbelievable. How can we waste time like this?
Go to volume 3C.
Separately, they can just on even hard copy, they can just put it on the visualizer and upload it for us.
In the other version, is it this contention?
I don't know whether they've uploaded the wrong version. What can I? This is very bad. I'm sorry.
Hard copy ले लो उनसे. फिर visualizer पे.
Normalers, we also don't work on hard copies. I'll read it, Maras. Let them email it. I just read it. There's a letter of 14 June 72 by Syed to Elliot bringing to his attention that the committee was to be appointed to raise funds for establishment, kindly see, for establishment of a college for the Mohammedans.
Okay, Judge, does this begin, Muslim minority wanted to establish a university for grant of degrees on its own,
Yes.
which would be recognized by the
Exactly.
government?
We ourselves were saying we-
That's page number 18, paragraph number 32.
Yeah, but we'll give you the final version. So, but therefore, it is what we understand by establishment is not the statutory form of establishment. That's page 64, relevant page 65, volume 3C. I've given the citation. Have you sent the right one? Now, let's B. Another letter of 10 July 72 from Evening Bearing Captain to Sir Syed, acknowledging letters of 14th and stating that if the institution, when established, shows a reasonable prospect of divisibility. So they also understand what established means. Well, therefore, I have been saying again and again, the concept of establishment under Article 30 is different from the concept of establishment through a statute. That's a constitutional right to establish. Even Sir Syed and the association and the minority never thought of establishment in the statutory sense. And this is, I'm talking about 1872. If the institution, when established, shows a reasonable prospect of divisibility and general success, and if the course of instruction is such to convince His Excellency that a bona fide effort is being made to afford sound secular instruction, he is prepared to devote 10,000 rupees to the perpetual establishment of a scholarship in the same branch in a European language. I haven't quoted it, Malas. He wants some European chair. That's okay. Then, Malas, there's a letter of 20th July. Syed to Mohammedan chief saying, intimating them that the lowest sum required for the establishment of the proposed college. Again, for the establishment of the proposed college is estimated at 10,000 and that subscriptions towards this have been invited and contributions having been come from the people of all classes. Then on 18th November 84, this is most important. College Fund Committee to the Viceroy government expresses that we wish someday when our endowments are richer and our schemes are completed, we hope to be in a position to ask the great representative of India, of Her Majesty, to confer upon us the legal status of an independent university. To confer upon us. So this is a conferment of the legal status. It is not establishment of the university. These are two separate concepts, and it is reflected in the contemporaneous communications. It's done now. And we wanted an independent, and I will show to your lordships, and I'll just presently show. Your lordships have it now. So I was referring, Millers, to 18 small a, b, and c, and d, which I've read to your lordships. Now kindly come to 19. If all my lords have it, Millers, I will read that. My lord Sir Surikant has it?
Yes, sir.
Justice Pardiwala, do you?
Yeah.
I'm sorry. It's now on the screen also. It's also on the screen.
Paragraph 19.
Now it's there.
So 19, third, it is clear from the correspondence and other historical material that such a college was envisioned as free of governmental interference. As such, there is no surrender at any point of the right to establish the institution that they had been envisioning. Even at the time, the founders drew a distinction between government interference on the one hand and supervision and support on the other. In this context, the proposed scheme for AMU College presented by Syed is relevant. The scheme reads, I have to mention first of all that management of this institution should be perfectly free from any control of the government beyond mere supervision. So you can supervise me, but you can't control me. That's Article 30. The following passage is crucial. The best educational institutions in Europe are either entirely or next to entirely free from any control of government of the country, and this in countries where rulers belong to the nation whose education is conducted. With how much greater force does this argument hold good in the case of India, where the government is almost wholly composed of persons belonging to a nation totally different from us in language and religion and mode of thought. By saying so, I simply mean to support my argument that it is next to impossible for the British government to understand fully our wants with respect to education or to superintend it in any perfect manner. The utmost we can expect from an enlightened government is to receive what we in fact do receive from our government, encouragement and patronage. If our university is intended to give sound education, the English government, as a matter of course, will patronize such institution. And if any direct pecuniary aid is given to us, we should not be unwilling to put our university under government supervision, provided no interference is made in the management of the institution.
Which is the year?
This I'm reading is
1902.
volume 3. I've given
No,
the,
it's not in the list also, it's not, date is not.
I'll give the date.
It's 1903. Yes.
No, it's not 93. Anyway, I'll give the date. 1870s. Anyway, so Malaz, the point I'm making is this is how it was envisaged. That you will give it a status. Right? But we'll be independent. Don't interfere with us. And that's why those provisions that the governor can inspect, these are all supervisions. Otherwise, there's no interference in the administration. On appointments, on admissions, on appointing teachers, on everything is controlled by the court. I'm not on Muslim and non-Muslim now, Malaz. I'm talking of pure administration. We're not concerned with Muslim, non-Muslim. The point was that the provisions that my learned friend read are provisions under 1906, equivalent to 1906, provisions of supervision that you don't fall foul of the standards. That's what it is. It has nothing to do with establishment. And giving it legal status is the establishment under the statute. So then, Malaz, then this very MAU, Malaz, all was taken over. This MAO was taken over by AMU. And the same thing happened in AMU. Exactly the same. No change. Whatever government control was there in MAO, the same was there in AMU. No change. That is, we have a chart to that effect. That is chart A in 1H. Just you note that. We've said so. We've demonstrated. So, Malaz, our concept of establishment was clear. That they can supervise was clear because they're going to give us aid. The same here, that's 1906. They regulated us that finally I can't, apart from the first ordinance, if I wanted to amend it, the court could amend it, but ultimately it will have the final approval. Every ordinance in Delhi University will have the final approval of the visitor. Okay. That's not administration. There's a whole complete confusion on the concept of administration. So, so this happened. This is the background on the basis of which the university was set up. Now, let's move from 90, because there are four, so to say, milestones: 1920, 1950, 1965, and 1981. 68 and 1981. Now, these rights got frozen in 1950. Right got frozen. If you now come to the conclusion was Basha was wrong by taking that test of fact, namely because you were incorporated, therefore you were established, therefore you did not establish the university. If that's wrong, then in 1950, I was a minority university, and that was frozen. And the same test would apply. And what is your lordships considering? What was the position in 1950? If I was a minority institution in 1950 established by the minority, which is clear, well, on facts it is clear, they've all been set out by your lordships. Fund was mine. Donations were given by Muslims, non-Muslims, even others. 30 lakhs was never given by the Nizam, as one council said. And all that was, and that was the condition precedent for establishing that you have to bring in 30 lakhs. We brought in, its value is over 320 or 40, 50 crores today. So, in what way did I not establish, other than the fact that I incorporated? I incorporated why? And that's also history, I can't go through it because there's no time. The history is this, that there were two schools of thought. And if the Muslims are conservative today, you can imagine how conservative they were in the 19th century. And there were two schools of thought. Well, there were two kinds of schools, what are called the Halka Bandi schools and the Tehsili schools. Halka Bandi is in the Halkas, those tehsils, and then the Tehsils, the schools were there. And the Muslim parents never used to want to send to these schools. Some of them were English speaking, they didn't want, the conservative elements didn't want that. But the Sir Syed element wanted a liberal education to copy the British. And that's how this whole concept came about. But without interference by the imperial government. And the imperial government agreed with it. They didn't interfere. Have your lordship seen any document in this entire proceeding, right from 1968 onwards, that the imperial government ever interfered? Ever interfered? No statute was ever refused, as suggested by the court. Never. They were never interfering. And the argument is, no. Because they had the final right of approval, therefore this is not established. That's a non-starter, according to me. So, a committee was set up. In terms of committee, there were two schools of thought. One school of thought says, let's move forward with Western education. Let's have our children be taught in the English language. That was one school of thought. The other school of thought was, no, we suspect these people. We don't want to go to these schools. We are against Sir Syed to set up this university. And the British said, if you are able to get 30 lakhs, if you are bona fide in your efforts, I will help you. And the statute itself, the 1920 Central Legislative Act, didn't have any element of interference with the day-to-day functioning of the AMU. Never. And then in 1950, it got frozen. Then what happened in 1965 was this act, and which was challenged by somebody. There, Chagla said it's a temporary provision, it's an emergency provision, but I will continue to maintain the character of the university. What did he mean by that? Character of the university means it's for the minority. It's not for the majority. One second. He had to support the act. Naturally, he had to then agree with Basha. How can a minister stand in parliament and moving an act to amend and say, no, 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 this is before Basha?
Before.
Yes, right.
Basha came subsequently.
Yes, that's right. It's before Basha.
No, but he did say, but that may not be binding on us, but he did say that he
Yes,
did
he
not
did.
believe.
I accept that. Manoj, he did say, Manoj. But
didn't
Manoj, I'll
believe
tell
that
your
he was
lordship
a minority.
again.
And he
frank-
he probably wanted that it should not be declared as a minority institution because let's also forget St. Stephen's came much down.
Yes. That's correct. Your lordship is right.
At
But-
that time, there was no question of reservations. It's like,
That's right. That's a separate issue altogether.
that was not the issue at all.
Yes,
at that
yes,
time.
that was not the issue at all. But anyway, Manoj, so that's what happened, Manoj, and therefore, de facto, it continued. That character of the minority institution continued. There was no interference. So from 1950 till 2005, there was no interference as a minority institution. So, Manoj, what is the occasion today to interfere? If Basha is wrong. If Basha is right, Manoj, then it's another matter altogether. And therefore, Manoj, your lordships will have to see the position in 1950 what happened and what the word established means in 1950, which I said in my opening argument, that the concept of establishment under the constitution is different from establishment under a statute because that is to seek recognition. And in the speeches, Manoj, that you will find, the people are saying, look, how will our children get jobs? And because Manoj, AMU, we set up the university with the approval of the British government, the second argument made was that we were loyalists to the British. So were the soldiers of India loyal to the British when they fought in the World War? So was Manoj, the Allahabad University loyal to the British? Everybody seeking a job in the government of then government was loyal to the British. Is that a test, Manoj? Is that an argument? All ICS officers were loyal to the British. Is that an argument? That's a communal argument. So, Manoj, let's not deviate from the essential constitutional question. Loyalty to the British or being there were several people who were not part of the national movement, Manoj. That didn't mean they were not loyal to India. Their concepts were different. Some people wanted social change. Netaji said, I'll revolt. I won't be part of it. I'll be part of the Allies. Axis. The others said, no, we'll be part of the Allies. So different concepts. So we can't put a status to an institution based on these kind of considerations. It'll be wholly irrelevant. And also, I think, very divisive. Then the concept of minority. What is a minority, Manoj? How do you determine then a linguistic minority in a state? There'll be several linguistic minorities in the state. How will you determine that? So this whole concept of you're not a minority at all. So if in a state somebody is in power in Maharashtra, Manoj, then who are the minorities in Maharashtra? What kind of argument is that? We were not ruled by the Pope, Manoj. It was the British Empire. The fact that they were Christians didn't mean that we were ruled by the Pope. So, Manoj, that's the other level of argument. Then, Manoj, the third level was that, look, this is an institution of national importance. Correct? It is an institution of national importance. Now, Manoj, look at it constitutionally. As a matter of law, can you say that a minority institution established under Article 30, which is our fundamental right as a community, cannot be an institution of national importance? Can it ever be said? In other words, a field of legislation where Parliament has the authority to make law will destroy my constitutional fundamental right. Can it ever be said? Minority institution is the furtherance of a constitutional objective. Why? And I said so in the beginning, no reservations in any institution. Coming back to the reservation issue, Manoj, if today there were reservations in this institution, minorities wouldn't have a place because 60% of the seats will go. And there are many institutions of national importance where reservation is not allowed, even under our constitution, even today. So that's again not an issue before your lordships. 1981, not an issue before your lordships. The only issue before your lordships is whether we establish this university or not. That's the only issue. Everything else will follow. Whether 81 Act is good, 81 Act is bad, all will follow. If we have established, then well, it will be tested on that basis. If we are not established, we're out. We're not a minority institution. That's the limited issue that your lordships will have to decide. And decided on the context of 26 January 1950. What do you mean by the word establishment here? And can, on the basis of what is placed before your lordships can come to the conclusion, yes, it was established by the minority. If your lordship says Basha is right because it was incorporated, you got legal status, therefore you're not a minority, that's another issue. That's what Basha decided. But that's what your lordships have to decide. As simple as that. This numerical test has no application. With respect, it has no application. And I'll give your lordship, since your lordships want it, just give it to my lord, the numerical test. You have it in on your printed. You have give it. Just, Malas, your lordships may note the provisions of the Constitution which refer to institutions while you do this, institution of national importance. Malas, kindly just note it. Article 62, entry 62, list 1. Entry 63, list 1. Entry 64, list 1. '67, list 1. Then entry 12, list 2, subject to Parliament. Entry 40, concurrent list. Like museums, mallards, of national importance, archaeological sites of national importance. Then Schedule 6, Section 3, capital A, small n, and Section 3, capital A, small b. These are various entries in which, mallards, the reference to institutions of national importance has been made. But these are only fields of legislation, mallards. These are not constitutional rights, mallards, which are given. Merely because you have the right to pass a law where a minority institution doesn't mean it's not a minority institution.
De facto.
Yes.
Happened.
And Manas, the other thing, just to say, we were established by an act of the Imperial Parliament. We could not been in list 2. Education was in list 2. We could not have been there. That's why it was included here. If it had been universities, it would have been regulated by the state. The union didn't want that. And it was passed by the Imperial Parliament. There was no question of it being included in list 2. Then the third issue is, Malas, if you were to include it in list 2, then each state will have its own control, each university in that state, Malas. Nobody wanted that to happen. There were only 3 universities of any character in this country at that point in time. Delhi University, Banaras Hindu University, and AMU. There was no fourth. That's why it says, and any other. Then the IIT came, the IIMs came, Bhabhi Katoma Energy, all that came later. 165 universities happened later. That doesn't mean that, that they don't have the character. And each of them will be peculiar to it. So then the other argument was, look at this university established in Annamalai. Annamalai was established because there was a private person. It's not a minority institution. Annamalai Malas was a private person who was the founder of that university, he handed over everything to the government and said, but I want, as a founder, I want control over the staff. I want control over nominations and stuff like that. They said, fine, you take it. But how do you apply that test to a university under 30 or a minority institution? I mean, each institution, and the founding moment is entirely different. For each university will be different, Mullah. See, you can't make an argument of uniformity that every university must be in the same manner, it's established in the same manner. It can never be. Universities anywhere in the world will be established in different manners depending on the time, the level at which society is placed. All that will be factors, Mullah. So that takes care of that argument, Mullah. The other thing is that, let me now see if there's anything left, Mullah. So I want to quit. Huh? There can be no surrender of a fundamental right. How can there be a surrender? Hold on. I can't waive it, I can't surrender it. If in 1950, I was an institution established by the minority, there's no question of surrendering anything. But if I have not established, and if Basha is right, that because I was incorporated, then of course it's another issue. So, Malads, the administrative argument that has been made is without reference to the scheme of the Constitution. It has no relevance. The only relevance is, was it established? Now, Malads, on surrender, in St. Xavier's, it says it is doubtful whether the fundamental right under Article 30 can be bartered away or surrendered by any voluntary act, or that it can be waived. So what is that whole argument? The reason is that the fundamental right is vested in a plurality of persons as a unit, or if we may say so, in the community of persons necessarily fluctuating. Can the present members of a minority community barter away or surrender the right under the article so as to bind its future members of the unit? The fundamental right is for the living generation by a voluntary act of affiliation of an educational institution established and administered by a religious minority. The past members of the community cannot surrender the right of future members of the community. The future members of the community do not derive the right under 30 by succession or inheritance. Very powerful words. Justice Matthew and Justice Chandrachud, as he then was. Also Kerala, Malads. Nor do we think that there is any substance in the argument advanced by Learned Counsel for Kerala that this bill has not introduced anything new, and the Anglo-Indian schools are not being subjected to anything beyond what they have been submitting to under the Education Acts and Codes of Travancore. In 1945 or 47, when those acts and codes came into operation, there was no fundamental rights, and there can be no loss of fundamental right merely on the ground of non-exercise of it. There is no case of estoppel here, assuming that there has been an estoppel against the Constitution. There can be no estoppel against the Constitution. So surrender, estoppel, waiver, I just have completely alien to our Constitution as far as fundamental rights are concerned. And 30 is part of fundamental rights. Yeah, like my learned friend talked about national character. That's nothing to do with the entry. Entry only says national importance. Now, Malas, the other, just so that, Malas, because I have no time now, I have 20 minutes. A lot of time. Actually, I'm happy your Lordship asked me to encapsulate it. I will be able to finish it. Now, Malas, I want to show you the present. I have a chart of the present universities established after 1950. My learned friend also made an argument. See, in the universities today that are established by the minority, there is a statement there that they are established under 30. But that statement could not have been there in 1920, Madam. It is the effect of Basha that that statement comes. Because of Basha. That can't be used that because there was no such statement there, Madam. You'll have to see from the facts of the case as to whether we were the ones who actually who established the university with funds that we collected, with the vision that we had, with the intention of setting up a university, with the idea of helping our community. a loyalty to the British for the, according to me, the gentleman was loyal to his community, not loyal to the British. By thinking of trying to help his community, the loyalty that he was demonstrating was that to the community. Where the poor amongst the Muslims who had no access to education. And whereas, may I just tell your lordship asked a very magnificent question. All these institutions of national importance, what is the national character of these institutions? We did some research, Malaj, and we found a very interesting feature. That in IITs, Malaj, which is page? Page 33 of 1G of our note, Malaj, very interesting. Such a committee, page 33, 1G, page 33. Yes. It's on the screen. Oh. One thing, huh? Yes. See, Malaj, page 33.
This is 2006 figures, I think.
Yes, yes, I'm only talking about the 2000 figure. Whatever figures I have, I'm giving it. I'm just showing.
That's the time when the reservation was made, which is telling.
That's the time when the reservation was made and it was challenged. IIMs, Malaj, your lordship has that paragraph 62 at page 33. About 1 out of 3 Muslim applicants is selected in IIMs, which compares favorably with, in fact, a somewhat better than the success rate of other candidates. Despite a better success rate, Muslims constitute 1.3% students studying in all courses in IIM. 1.3%. This is the state today after independence. And whatever little the community has, you want to take that away also. And in absolute numbers, there were only 63 out of 4,743. IITs. In the case of the IITs, out of 27,161 students enrolled in the different programs, there were only 894 Muslims. The share of Muslims in postgraduate courses is just about 4%, but it is even lower in undergraduate courses of 1.7%. 1.7%. This is the factual, this is the national character of IIT that my learned friend was talking about. Only 1 out of 25 students enrolled in undergraduate courses and only 1 out of 50 students in postgraduate courses is a Muslim. The status of Muslims in PG courses is equally disappointing. Only about 1 out of 20 students is a Muslim. This is significantly below the share of OBCs 24%, SCs, STs 13%. So this is the state of affairs. So, Maharaj, what do we have? We have one university, which is a university of excellence. And you want to say today that no, take it away. An argument is it's too good to be a minority. And even the private survey shows only say 1.6% are Muslims. In 2019, I'm talking about, but that's a private survey, Mother. But this is government for IITs and IIMs. I'm talking about IITs and IIMs. 2019 private surveys say that, and done for the IITs. So now, Mother, kindly go to my chart in the beginning of this note. Yes, the index, table of contents.
Based on the entrance test, we can. What turns on? Nothing turns on.
No, I didn't say anything turns on it. You said that these institutions must represent national character. So what's the character they're representing?
It's non-denominational.
It is not denominational. It's a right, fundamental right given to the minority. Diversity, we are admitting. But as I said, this university has graduated thousands and thousands of non-Muslims. St. Stephen's, but thousands of non-Muslims, some of them sitting here, some of them sitting there. Madhav Menon was a product of AMU. He did his LLM and PhD there. So what are we talking about? Secular nature of education can never be discarded, should never be discarded. If it is, it's violative of people's fundamental rights. But we are imparting secular education. But we have certain elements that have something to do with our community. And as I said, if my learned friend is right, and he's right, there was no reservation. But the fact of the matter is there was institutional reservation. So from AMU college, people came into the university. So there was enough Muslim students because of that. From the schools, they came to the university college. That's how much the representation was maintained. We didn't need reservation. But if you throttle that, Mullahs, then where will we go? It is to make up for the lack of representation in other institutions that you have an institution which is an institution of excellence. Now, on what? Why do you want to take it over? I don't understand this, Mullahs. I've not understood the rationale for it. That why do you want to take it over? Is there something that this university has done which, Mullahs, is anathema to our constitutional values?
So nobody's no one is taking over.
No, you are making an argument that because it was incorporated, it is not established. That's your whole argument. You are taking over, but you are saying it's not established, therefore you'll take over. What will be left? Mullahs, you can appoint anybody you like then. There'll be 60% reservation also. 50 plus 10 now. Then what will be left? So these are very dangerous arguments, Mullahs. I mean, one little citadel of learning, one little small citadel of learning in a country of 120, I mean, it's a billion people, what? What are you, 1.4 billion people, what are you trying to do? Small institution. So, Mullahs, just the contents. One factual argument on administration, Mullahs, I've already done that. I've shown that. Mullahs, I've given the pages because it's all structured here, Mullahs, with the pages and the cross references. Broader analysis of Article 30. Just come to page 11. At the bottom, broader analysis of 30. The respondents have argued that in order to determine whether a particular institution is a minority institution, a twin test must be satisfied. First, the minority must show that they established it, and second, they must demonstrate that they are administering it. That's the wrong test. It's an absolutely wrong test. This argument of the respondents is mounted on the strength of the word "and" in establish and administer. That's the learned solicitor, my dearest friend, Mullahs. He's been arguing this. So, Mullahs, I've set out the law on the subject, Mullahs, and I say Xavier's, Kerala Education Bill, all those opinions, Mullahs, I have given the passages. The community in question is the religious or linguist minority, and the minority community established the educational institutions. And it must not be overlooked that 31 give the minorities two rights, to establish and to administer. Mullahs, I've done that. So go back to the contents, Mullahs, now. So this is on 2. Then no surrender. I've shown that to your lordships. Then declaration AMU is an institution of national importance. I've dealt with it. And legislative debates do not render AMU a non-minority institution. Right? Your lordships have to look at only the aspect of establishment. Anything else? Yes, I want to show that chart, which is that page. 1H. Well, I hope you have it. 1H, yes. Now, this is, Mullahs, there are two charts. This is, the first chart is the comparison between Aligarh Muslim University and MAO College. Your lordships will find that at page 1. MAO also had external supervision, just like AMU. Now, no different. Which one are you going? You don't give the wrong one. Which is the chart? Well, give me your chart. Why are you giving me the wrong chart? As it is. This is the correct chart. The numbering has gone wrong. Shit. I'm sorry, Mullahs. I apologize to your lordship.
1H, right?
This is his
One is Mr. Farasat.
It's the same chart. So which one is your chart?
So I'm just emailing it to them right now. What is it?
Anyway, Malas, what I want to say is that whatever restrictions were there in MAO college in terms of supervision, the same came in the AMU. No different. Consistent with that statement, we don't want any interference. We are acceptable on supervision. And MAO was accepted by Basha as minority. The only change being it was incorporated, therefore you lost your minority status. Overriding powers were there even in MAO. It's just simple. It has to be, somebody has to ultimately be responsible. In any educational institution, you just can't leave it to the institution and the principals of the college. So the same. Then the second one, second chart, show the second chart at least. It's there on the screen. Now you will see the second chart is page 8, it starts, Madhur, it's on the screen. Now what we've done is we've looked at University of Calcutta, Aligarh University, Alia University and Haryana private universities. You will find similar provisions in all universities. So they are not minority institutions because there's a right of inspection. Page 15C, Madhur. I agree. I'm saying it has the same provisions. That right to inspect, which you talked about, as far as the AMU was concerned. You said you have a right of inspection. See, it's a right of inspection here. How does it change the minority nature of the institution? Statute amendment is the same. You can amend the statute the same. They can amend the statute. So how will that make a difference to the minority character? And IA is 100% aided. Page 15, just see, Malaj. Governor of Haryana shall be the visitor. The visitor shall have the following powers. When present, he shall preside over the convocation to call for any paper of information relating to affairs of the university. On the basis of information received, he is satisfied that any order, proceeding, or decision taken by any authority is not in conformity with the provisions of the statutes. He may issue such directions as he think fit. Notwithstanding anything contained, the university shall be bound to comply with all the rules, regulations, this thing. And powers of government to inspect universities and academic and everything, and audit, as my Lord Justice Datta put it. Same provisions. Does it mean that these universities which are incorporated as minority institutions are not minority because of these conditions? Alia also the same. Government control is not the test for inspection and for maladministration. This is to ensure that there is no maladministration. And Haryana Act is for all institutions, whether minority or non-minority, all institutions. So the tests are wrong. The application of the test is wrong. The constitutional conception is wrong. The approach to Article 30 is wrong. I mean, it would be an unfortunate day, Malaj, in a secular country, wedded to plurality, wedded to the cause of an India which is inclusive. We are arguing here that take away this. It was never a minority institution. All I can say is it will be a sad day if that ever happens. Thank you very much.
Thank you, Mr. Sudhir.
I may be excused.
We have, I have a very short submission, but I'll take about 15 minutes.
We'll not be able to assemble now after today because we have another set of matters. So today we have to have a cutoff on this matter now. Whatever you want to say, you can supplement in a short note, maybe a couple of pages.
That's what I do, Mulad. I'll only point out to your lordships that much of what has been said is very beautifully reflected in David Lelwell's book called The First Generation of Aligarh. Mulad, the entire conspectus of how the Aligarh College, the MAO College, was conceived
what was the kind of support it had from what they call the COM, the community, the sort of community support it had, and how that moved forward to becoming finally the AMU. Because there are 3 chapters, I will mark them out. There are 3 chapters there, which I believe will be edifying and important in actually fortifying whatever has been argued with your lordships. Just 2 or 3 points that I will put down. My lords, I will just indicate. One is on nature of rights. My learned friend, Mr. Dwivedi, has talked a little bit about positivism and the difference between morality and law. Lordships are all familiar with it. My lords, I have argued, and I would reiterate that the issue of morality and law is not what is involved here, but the issue of constitutional morality, which your lordships have conceived as a manner of looking at the constitution in a wholesome manner, started with Keshav Nand Bharati. Where did that take us in the present circumstances? My lords, have a little bit on that. On non-denominational issue, my lords, I'm going to highlight the fact that, of course, there was the Wood dispatch and so on and so forth, saying that we now prefer non-denominational institutions. But the fact remains, the non-denominational institution didn't prevent them from saying that we are setting up Banaras Hindu University, we are setting up an Aligarh Muslim University. And when the Aligarh Muslim University is set up, my lords, the logo and the motto look very clearly, very clearly and specifically Islamic. And in fact, a verse from the Quran is quoted in the motto, which is taught man what he knew not, Quran verse 96. My lords, I'll put these things in my supplementary submissions. Your lordships may please consider them. I'm grateful, my lords. Thank you.
Yes, Mr. President. I just conclude within 5 minutes, unless you lordships permit. First, quickly, because the first submission, I just have 2 short points of rejoinder. Because the first submission is insofar as establishment is concerned of 1920. And the argument was that by establishing, you have taken away the denominational status because you gave away right. That is what the solicitor argued. Now, in response to that, I have compared all the universities, the 2 denominational universities, namely the BHU and AMU, and the non-denominational, that is Allahabad, Bombay, etc., which were also through an act of the imperial legislature. I have compared that to show that, in fact, in these enactments, that is denominational statutes, the legislature went way far ahead in terms of giving the autonomy. And that comparison your lordships will have in 1H is my written submission in rejoinder from page 15 onwards. For instance, broadly, I'm not going to take in detail. The broad point is this. Even in the opening of those statutes, the statutes mention that this is for all subjects of Her Majesty's or His Majesty's government. So, the very opening of those statutes, Allahabad University, Calcutta University, etc., they say it's for all subjects. No such provision is there in AMU Act. Similarly, the Chancellor and the Vice Chancellor are government officials. They are, my lords, either the Governor General by name, by designation, they are government officials. Here, the power is left with the Governor General. Here, the power is left with the Governor General, and the persons who have been appointed pursuant to that power, when we look at de facto and de jure together, are Muslim persons. So, the power was left so that it could be exercised to appoint a Muslim. Otherwise, you would have by designation named the Governor General or or some government official as in the non-denominational acts. Because similarly, there is a power of something called fellows in these enactments. There is a whole bunch of fellows which are there. And they also, my lords, are all government officials. No such provision exists. Power to grant decrees. Who grants the decree? My lords, the government official grants the decree. Here, the university grants it. So the broad point is this. Plus, the space of court, executive council, and AC which has been created, it is, of course, subject in some aspect to the supervision of the higher authority. It's like 2 hands need to clap. The day-to-day administration, the decision, the initiation keeps on coming from the university body, which is minority body. And on some aspects, there's a confirmation by a higher body. Of course, the colonial government will keep some level of control with it. It is not going to establish a Muslim university and say, out you go, you do whatever you want. Well, that's quite clearly understood. So in that respect, the initiation stays with us. And that is the fundamental distinction. The chart has many examples. On paucity of time, I can't go into it. But if you lordships will just examine that chart, on every aspect, it will show the denominational nature is evident from the level of autonomy granted vis-a-vis the non-denominational universities of the relevant time. Well, that's submission one. Well, submission two, your lordships have the entire canvas before your lordships today. Everything has been argued on facts, on law, on decisions from 1820 onwards till 2024. Because the question, there are various approaches available to your lordships as to in this reference. Because what I would commend to your lordships is that your lordships will restrict, as Mr. Sibbal argued, to 50 and not test any specific amendment in this reference. The reason is this. In particular, my lords, the declaratory amendments of 1981. Because the non-declaratory portions are not in challenge at all. They have never been challenged. What was challenged and what has been set aside by the Allahabad High Court is the declaratory portions. The reason is this, my lords. Because it is the constitutional obligation of the executive to defend a parliamentary enactment. If today the executive has chosen not to defend it, the parliament is without a voice before this constitutional court. The parliament has spoken through an amendment, but it doesn't have a defense before this court on that amendment. Because that is something very fundamental and core. For that reason alone, my lords, everything is before your lordships will consider it. But don't test the wiries because there is no constitutionally valid defense before the court today. And my lords, my written submissions your lordships will have, page 13. I'll just formulate it quickly, I won't take it. Because the executive has a say in legislation. The say is at the stage when when the assent is granted by the president. Under Article 111. The president can, as your lordship knows, send it back. That is an aid and advice function. It can still come back and then the president has to approve. So, my lords, the limited say on the legality or constitutionality or desirability the executive has. Once it's a one-time exercise, once the assent is given and once a law is notified, the executive loses the power to either, my lords, go contrary to the act in terms of enforcement or not to defend it. Because, my lords, constitutionally, otherwise it will upend everything for the reason. Just test this. Let us say, my lords, the executive is today, it wants to overrun an earlier constitutional amendment. I'm just hypothetical, pure, not in this case. It wants to overrun an earlier constitutional amendment. It doesn't have the numbers in both the houses. What does it do, my lords? It has a frontal litigation. It chooses not to defend as a defendant. By the same logic, it can even challenge an earlier amendment. If it is entitled not to defend, surely the executive can even challenge an earlier amendment. And, my lords, it is not the responsibility of Aligarh Muslim University or any of the private petitioners on this side to defend the parliament. The parliament has spoken in our favor, therefore we are defending it on that particular amendment. But it's not the responsibility. The constitutional obligation solely and exclusively lies on the executive, and they don't have a choice because the prerogative of testing the constitutionality is the exclusive domain of this honorable court, of the constitutional courts. It is not with the executive. In fact, that changes the separation of powers. If the executive were to decide what is constitutional and not, and then defend accordingly, that will completely upend the structure. So my respectful submission is, even a law which the executive of the day believes to be unconstitutional, it is constitutionally expected and obligated to defend it before a court. That's why, just as an example, the Brown versus Board of Education, the Attorney General for Kansas had, for the executive express.
If he wants to raise, I didn't dwell
So,
much on.
I'm not.
The new arguments.
It's a response to what was argued. So, the submission was this, that although the executive's view declared was that segregation as a policy is not proper, it's not desirable, it is possibly unconstitutional. But before the 9 judges of the US Supreme Court, the executive, through the attorney, defended it for the reason that the executive has no other option. So, because the parliament doesn't have a voice today, my respectful submission would be that aspect of just that declaration, your lordships will leave it at a subsequent stage. Your lordships may consider deciding in this matter if the executive has that option of disagreeing on it. That's my respectful submission. I'm extremely clear.
So, Shamshad, then.
My lordship, I had argued 4 points, in fact. One was recognition, second was group rights, and third was the concept of educational institution is very broad. And for that, I had taken through your lordship with the Basha principle itself. The only thing that I could not complete that day, and I had given the pagination, my lord, and your lordship had noted, Keshwananda Bharati, para 535A, volume 1E. I have given in volume 1E, page 78, my lord.
Yes,
535, I'll not read, my lord.
yes.
In the background of entire minority rights from pre-independence till formation of, or till constitution, has been set out. And then in that background, it has been stated that it is in the nature of essential feature of the constitution. So that is one aspect. Then coming to my lord, your lordship's judgment in Puttaswamy. In Puttaswamy, my lord, para 298, your lordship may have this paragraph at page 500 in volume 5B. Your lordship has stated that constitution has recognized inalienable rights. My submission is, my lord, fundamental right chapter has recognized many inalienable rights which existed pre-constitution. Article 30, what it does, it recognizes the right. Once you recognize those rights, either in the present regime of Constitution of India or prior to the Constitution, the question of surrender of your right does not arise. So the surrender argument that has been advanced in relation to one of the components which has been held by this honorable court in Keshwananda Bharati case, that it is in the nature of basic feature of Constitution. So to say today that surrender of autonomy or rights falling in part 3 of our present constitution is neither contemplated in today's constitutional scheme, it's my submission, my lord, nor this court will recognize that it was possible to surrender those inalienable rights in favor of erstwhile sovereign powers. That's what they have argued, my lord. Dr. Dhawan has already highlighted in his written submission, saying that how minority rights were recognized even prior to constitution. So there is a list already. So in that context, my lord, Article 29's interpretation of your ladyship Justice Ruma Pal in TMA Pi, though she has dissented, but that dissent is not to say that minorities' right was lesser than what majority has said. The dissent is to say that, see, majority is saying that Article 29 to 50% reservation of St. Stephen's has to come through a state intervention. In many circumstances, even that is not justified. So your ladyship has spoken to say that, see, if you are fixing, there may be a circumstance in which beyond 50% would be required for those who have established their institution. So in that background, there is dissent of Justice Pal. And to support this argument, para number 381 of your ladyship Justice Ruma Pal in TMA Pi at 5A, page number 736, your lordship may kindly consider. So in this background, my lord, last line, my lord, when your lordship is considering interpretation of Article 30 and taking a decision whether Basha should be reconsidered or not, your lordship, this judgment is going to decide the future prospect of Article 30. I can say this. It will have implication on many aspects of minorities' right in the country. The only submission I am making to your lordship, that while deciding this, your lordship will take a view that advances Article 30's protection. And the way they have argued as if it is only a decorative provision. That decorative provision, it will not turn into decorative provision of minorities in the country, my lord. That's my respectful submission. Your lordship will give a broader interpretation.
Thank you, Dr. Dhawan.
Grateful.
Thank you, everyone.
Very grateful, very grateful.
Deeply obliged.
Really deserve that. Arguments concluded. Thank you.
Deeply obliged.